Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1006, United Parcel Service, Inc. Petitioner versus Postal Regulatory Commission. Ms. Sullivan for the petitioner, Mr. Shi for the respondent, Mr. Longstrap for the interveners.
Good morning, counsel. Ms. Sullivan, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. Kathleen Sullivan for UPS. We are back before this court again because the Postal Regulatory Commission has once again defied its obligation under 39 USC 3633A3 to ensure that, quote, competitive products cover an appropriate share of the institutional costs of the Postal Service. This court remanded in its April 2020 decision because the PRC had failed in its prior order to consider institutional costs that are, again, I quote from 39 USC 3633B, uniquely or disproportionately associated with any competitive products. The remand goes back, we're 3 years and 250 pages later, and we're in the exact same position we were before. Why? Because the Postal Regulatory Commission said, okay, we had the remand, and we now find again that there are not a single dollar, no disproportionately associated costs. That is contrary to the statute and it's contrary to the court's prior order, and another remand is required. And I'd like to begin with why the new order is contrary to the statute's text. And for that, I really don't need to go beyond the court's previous order in the April 2020 decision. Section 3633A3, which incorporates the definition, the requirement of 3633B, that you look at disproportionately associated costs, that cannot be subsumed by a 3633A2 analysis. So even if the PRC has done its costs attributable analysis under 363A2, this court said the statute has two separate requirements. You have to look at the costs attributable, and then separately, because 3633A3 is not subsumed, you have to look at the costs.
So on the statutory interpretation question, before getting into what exactly the commission did, would you agree that it would be okay and consistent with our remand opinion if what they had said was, number one, in theory, the A3 costs could be broader, just requires an association and not causation. And then point two, we've really tried, but we just can't find a non-arbitrary way of measuring costs that fall within that difference. And so that's the reason we're not identifying costs in that bucket. Now, I suspect you certainly disagree that's what they did, but if it was what they had done, would that be okay?
Yes, Your Honor. If that's what they had done, that would be okay. If there's separate legal requirements and the Postal Regulatory Commission had gone back in earnest, using the best economists in America that it has access to, and had done an actual effort to discern, identify, and quantify costs disproportionately associated, then they would have an escape hatch from the 2020 order. But that's not what they did.
And I just ask in terms of our language in our prior opinion.
Yes, Your Honor.
So is that hypothetical scenario what was accounted for by our phraseology when we said, not only has the commission not adequately explained why the statutory phrases at issue here have similar meanings, but nor has it demonstrated that these statutory categories, even if distinct in meaning, nevertheless coincide in application.
That's exactly correct, and they haven't done that this time either. So even though you afforded them the opportunity to show that disparate meaning as a matter of theory, but practical convergence as a matter of fact, there is no such showing in this record. And I'd like to point to some key kind of smoking admissions in the order that prove my point, that this was not an empirical inquiry, it was an ipsa dixit. If we look, for example, to page, the order statement at, well, let's start with their bottom line. The bottom line is at Joint Appendix page 1132, and I'll quote, the PRC says there are no costs uniquely or disproportionately associated with competitive products other than those that are also classified as attributable. So that's the bottom line, 1132. And if you look to nothing else on 1132, look to the cite to JA 500. So this is a cite to a prior order. And what's happening at JA 1132 is they say, there is only one economically sound, to go back, Judge Garcia, to your point, they say there's only one economically sound way to do cost allocation. And that's to rely on our 3633A2 methodology. That is reliably identified causal relationships. So what the Ipsy Dixit on 1132 is, and let me read it to you because it's quite stunning. JA 500, which is referred to on A 1132, says the only economically sound method in the universe I added that, to measure the association of costs with products is through activity-based costing, which is based on reliably identified causal relationships. So there's Ipsy Dixit number one.
So that's a good example. Why can't that be read to say there is currently no economically sound method to measure that cost? And I would point out that when the commission discusses this issue, I might get the exact pages wrong, but it's around page 105. There are a lot of comments that come in and say UPS has a method, but that's arbitrary. And they're really going around this question, is there another method?
Yes, Your Honor, we think it's contrary to statute, and it would certainly be arbitrary and capricious to say there is no other method. Cost allocation is done all the time. You have the report of the prior utility regulators. Private companies allocate costs all the time. If you can't find a perfect method, you look for a pretty good method. And we cite numerous cases to the court, this court's precedent, saying if you don't find a perfect method, uncertainty is not enough. You know, Net Coalition, American Hospital Association, Wisconsin versus EPA. Your Honor's prior test is you have to show it's impossible. So Judge Garcia, even if they quibble with our tests and they think some other tests are not so great, they haven't come close to meeting the impossibility bar. And I want to make one more point about the Ipsy Dixit, Your Honor, and this is a crucial other record cite in answer to your question. If you look at Joint Appendix page 1170, this is an extremely important page. This is page, I believe, 100 of the order. This says joint costs that are simultaneously incurred by the distribution of institutional and, of market dominant and competitive products. And this is the key language on JA 1170. It is their very nature that such a relationship does not exist. In other words, can there be a relationship, disproportionate association between a competitive product and joint costs, which are captured in the institutional bucket? And they say no, as a matter of theory, it cannot exist. That's wrong. The whole point of 3633A3 is you have to look at that great big institutional bucket, which is almost half the cost of the Postal Service. This court approved in the 2018 decision the cost attributable methodology. We're not quibbling with that here. That was an A2 case. But that methodology is so conservative, it looks to reliably identified causal relationships that it leaves this gigantic institutional cost buckets. And 33A3 says go into that, and 3633B says go into it and look for disproportionately associated costs.
So can I ask this question as a follow-up to? Go ahead, Judge Rogers. Please, Judge Rogers.
Sorry, is that the Chief Judge?
Please go. Ask your question, Judge Rogers.
Thank you. Counsel, this is Judge Rogers. I'm on audio only because of an internet problem. In any event, what I'm not totally clear about is why should this court, following up on Judge Garcia's question, read what the commission has said in a way that, as I understand your response, does not indicate that it went back to square one and redid all of its empirical analysis, relying on studies, et cetera. Why is this court not required to look at the current order in light of the full record that was before the commission?
Good morning, Judge Rogers. It's wonderful to hear your voice, and I would like to answer your question as follows. The order must be reasoned and reasonably explained. And saying you did a lot of studies is not enough, and saying that you have quibbles with the commenters' proposed methodologies is not enough. You have to show how you, the Postal Regulatory Commission, tried a regression and it didn't work. We tried another form of econometric analysis and it didn't work. I would challenge my friend on the other side, Mr. Shi, to show you a single page anywhere in the record where the Postal Regulatory Commission names an econometric regression or other approach that it tried to allocate the costs in the institutional cost buckets either to competitive or market dominant. It simply did not do that. So Judge Rogers, they can quibble with a lot of other studies, but the fact that you quibble with our studies goes only to how to perform a regression. Our legal point is that something, a regression or an analysis, must be performed under 33A coupled with 3631B, and they didn't do it. They do not name it.
Can I ask a question about that? Earlier you used the word.
Let me follow up. So your view is that this court must interpret our previous opinion to require more than, quote, merely considering. You're saying, as I understand it, that our prior opinion required more than consideration in the sense of, yes, we looked at this, but actual empirical studies.
Yes, Your Honor, that is our position. We think whatever the meaning of consider is in the statute and in this court's prior order, it cannot be satisfied by saying, well, we don't think those costs exist. If you don't think there are any costs associated disproportionately with competitive products, with packages, and that defies common sense because, of course, you need bigger trucks to deliver packages. You need different scanners to scan packages. There's a host of costs we identified, which as a matter of common sense would seem to be disproportionately associated with competitive products. That means more associated than not. It doesn't have to be a reliably identified causal relationships. We've been there, done that in 2018. We're not arguing about the attribution methodology. We're saying that Congress told you to do two things, and you only did the first, and then you said the second is subsumed in the first.
So there's nothing wrong conceptually with an approach under which the commission would say, yes, there's a conceptual distinction between these two, and yes, there may well be these costs, but to paraphrase your argument, you're wrong to say that there's an impossibility threshold because there's an economic soundness overlay. So what we mean by impossible is it's impossible to divine those costs and assign them appropriately not because they don't exist, but because there's no economically sound way to do it.
That's right, Your Honor.
And you'd be okay with that.
Well, Your Honor, we think I'm into my rebuttal time, and
We'll give you we'll make sure you have rebuttal time.
Is it acceptable for me to answer that question?
Yes.
And there were a couple of more points I just wanted to leave you with.
Sure.
So I'm asking for additional time, but you stop me whenever you want to.
Sure. No, we'll make sure you have rebuttal time, so you're welcome to answer the question.
Thank you very much, Your Honor. So the answer to the first question is it's conceptually fine to say Congress told us to do two things, but we really tried the second and it cannot be done. That has to meet the impossibility threshold. It is not met. It is not met on this record. Why? Because economic soundness, and I think I wasn't that clear on the importance of Joint Appendix 1170. Let me try it again. The court, the PRC said anything that is economically sound, an economically sound analysis is coterminous with, synonymous with the A2 incremental cost test, reliably identified causal relationships. They say it's the same thing. In other words, they say there's no other method in the universe that could ever determine the allocation of costs between competitive and market dominant products other than the A2 test, which has now been amended to be the incremental cost.
Seems to me the dispute then comes down to whether we agree with everything you just said, except that unless we read it to say no such method exists today, right now, and we really tried to figure it out.
Yes, well, but Your Honor, I want to just qualify that a little bit. Congress doesn't enact statutory provisions idly. It put A3 in on top of A2 and A1. And yet the Postal Regulatory Commission's purposes, never mind, they really didn't mean it. And if you're going to tell Congress it didn't mean that you have to perform a regulatory analysis that you shall perform under a mandatory provision of the statute, you better have a pretty darn good record of impossibility. And I defy the Postal Regulatory Commission before this court today to point to a single place where they said, we tried a test different from UPS's regression and it didn't work. No economist in the universe would bless it. That they didn't come close to meeting that. But Your Honor, I think what's telling is they fall back on other arguments, which I'll dispatch very quickly. One, they say, well, we have the greater power to eliminate all appropriate share, and that includes the lesser power to set the appropriate share at whatever level we want. That's easy for this court to reject. That's certainly not what Congress intended by saying they could eliminate the appropriate share. Maybe you could if there were no packages and you had no competitive products to allocate costs among. Maybe you could do that if the Postal Regulatory Commission got really good at attribution and it attributed 100% of its costs. But the eliminate proviso is inapplicable where you're throwing 40% and soon 50% of your costs over into the unattributed institutional cost bucket. And then last they say, Your Honor, and this one I really think bears special mention because it's really so surprising. It's a surprisingly defiant thing for a regulatory body to say. They say, well, market conditions are fine. We can trust the Postal Service to take care of this because it turns out right now, the formula makes them allocate 10% or maybe 11% of the costs to competitive the institutional costs to competitive products. But we looked at what the Postal Service was doing, and last year they actually allocated 39.2% of institutional costs to competitive products. So that's fine. If men were angels, we wouldn't need government. And if regulated entities could be trusted to look after their own obligations through their own incentives, we wouldn't need regulatory bodies. So it's really quite surprising that you would say there's no need to apply the formula. So in sum, let me close here. I'll try to be brief, but I want to go back to 2018 because it's very important. Here in this courtroom, before the panel in 2018, the counsel for the Postal Regulatory Commission, Mr. Shi, represented to the court, this is at the oral argument audio at minute 39, said, please approve our A2 methodology for attributable costs attributable. And don't worry that that's going to create a competitive deficit that's going to create an unlevel playing field and lead the Postal Service to underprice package shipments. Don't worry about that because there's a rulemaking going on. There's the A3 rulemaking going on. And what Mr. Shi told the court on behalf of the commission at that time is the A3 rulemaking is going to make sure that unattributed costs that are disproportionately associated with competitive products will not just, and I quote, vanish into the ether. In other words, we're going to find a positive quantum of institutional costs that that competitive products cause and therefore have to cover. The formula came back with the same formula, 10%, 11%, not 39.2%, not 50%. And that was an important representation to this court because, Your Honor, this court wrote in the 2020 opinion, this is at 890 Federal F3rd at 1067, this court has no reason to doubt that the requirement that competitive products cover a share of institutional costs will adequately ameliorate any competitive deficit left by the PRC's approach to cost attribution. We're here today because that promise was not met. No amelioration. There is a competitive deficit. It defies the purpose of the statute, which is to level the playing field, and therefore it's contrary to law.
So I have one last question just about the competitive conditions. You've said a few times there's a competitive deficit. And one way of thinking about prevailing market conditions and what the commission looked at here was, is there an indication in the market that the Postal Service is underpricing its product? So in that lens, the data, for example, that all three market participants have consistently been raising prices above inflation, et cetera, seems a compelling indication that it might be justified for the commission to do exactly what you described, which is we're going to hang back until there's some indication of prices being too low. And my question is to you, what's the best indication in the record that USPS is actually underpricing its products?
Well, Your Honor, first, we don't think that's the thing we have to prove. We have to show is that the Postal Regulatory Commission is failing to require that the Postal Service that competitive products cover their cost. But we don't think we have to meet the test, right? Let me come back one step.
Certainly if they were ignoring disproportionately associated costs.
Yeah.
I'm trying to ask separately just about the provision on.
So 3633B says consider two things, competitive conditions and consider disproportionately associated costs. The answer to why the competitive market piece of 3633B doesn't excuse the failure to let competitive products not cover their costs through not finding any disproportionate association. The answer to that is one, factual. It's undisputed that the Postal Service still has enormous financial losses. You can take judicial notice of last year's numbers, $6.9 million in financial losses. It's difficult to square the proposition that the market is functioning in a healthy manner with those financial losses. And the Postal Regulatory Commission says in the order that it doesn't have to consider financial losses, which is surprising, Judge Garcia. If they were actually considering competitive market conditions, you would think financial losses would be relevant to that. JA 1102, appropriate share is a discretionary pricing review, not a costing exercise. And again, JA 1214 to 15, it says financial losses are irrelevant. Financial losses are irrelevant to appropriate share determination. So we think it's arbitrary and capricious to say you're looking at competitive market conditions, look at a couple of price increases, but ignore the losses. We think that a remand order should clarify that financial losses should be considered as part of the appropriate share analysis, and that 3633B by its terms compels that by the reference to competitive conditions. But Your Honor, the second answer is really, again, that's not through any work of the Postal Regulatory Commission. It's undisputed here that the Postal Service, remember, the Postal Regulatory Commission says competitive products have to cover maybe 9, 10, 11%. Maybe if this dynamic formula keeps really working, we'll get to 12%. But the Postal Service is already finding that competitive products cover 39.2%. So the Postal Regulatory Commission's formula is not helping out with these competitive conditions. And that comes back to my argument about trust. They're saying, trust the Post Service. It's going to be a profit maximizer. That's inconsistent with financial losses. But that's not, the Postal Regulatory Commission's job is to ensure, not to trust, but to ensure that the Postal Service will handle competitive products in a way that makes them cover their costs. And all that is in the service of a level playing field. It's rather astonishing that the Commission says, well, Congress got rid of the break-even scheme. Yeah, the break-in scheme said they couldn't make a profit, but it didn't say they could make a loss. And if institutional costs are half the costs, and if competitive products are 40% by the Postal Service's own reckoning of that institutional cost bucket, and the formula says competitive products have to cover 9 to 11% of the loss, that is an arbitrary and capricious formula, even if it's not contrary to law. We've suggested various things that they could do that would not be arbitrary and capricious. You don't have to accept our proposal. We say start at 39.2%. Take the attributable cost share that represents competitive products, 43.5%. It's fine if you don't like the proposals, but we would ask at a minimum that the court remand with the instruction that you can't have a null set for disproportionately associated costs. You can't come back 5 years and 2 rulemakings later and say, yeah, disproportionately associated costs, Congress wanted us to find them, but I'm sorry, we tried, we didn't try very hard, but we think it's by definition impossible. We didn't show that it's practically impossible. That's not good enough. They've got to find something more than an null set. They should take into account financial losses, and they should follow, last point is 3922B, very important adjacent provision of the statute that this court should interpret as part of the structure. These provisions all work together. And 3922B says you must allocate appropriately total institutional costs between competitive and market dominant products. That means 3922B and 3633A3 and 3631B are the mechanism by which you can do that. Right? We've cited on page 41 of our brief a prior postal commission order that says it's the mechanism by which you do it. If you're not allocating costs between competitive and market dominant products, you're not satisfying 3922B, 3633A3, 3631B, contrary to law, arbitrary and capricious. It's a big thing to ask you to remand again, but we would respectfully ask that you again remand with guidance this time so that we don't, Judge Rogers, have another futile exercise in saying we looked at other studies we didn't like. The Postal Commission has to show that there's a study it performed that satisfies the impossibility test. Thank you, Your Honor.
Thank you, counsel. Mr. Shi, we'll hear from you now.
May it please the court, Mike Shi for the commission. Petitioner has just made what I think is a fairly remarkable admission from the podium, because Petitioner has just conceded that the bottom line of the commission's order is both lawful and consistent with this court's remand decision in 2020, just as long as the commission explained itself adequately. So I think the dispute now is relatively narrow, and it focuses on whether the commission has itself explained its reasoning. And you'll find if you have just even a cursory look at the pages that the other side cites, that their assertions of ipse dixit are just that, ipse dixit. So on the so-called smoking gun page of JA 1170, they cite a sentence in the middle of the paragraph, but they ignore the sentence just 2 ones down that says detailed analysis supports the commission's conclusion that it cannot reasonably estimate which portion of unattributed inframarginal costs are more related to competitive products than market dominant products, as estimation implies even a minimal level of accuracy and would be arbitrary. And if you look at the commission's actual reasoning as opposed to the cherry-picked statements that just sum up the commission's conclusion, you'll see evidence of this very deep consideration. A very good example comes from the discussion of trucks. And so this is the other side's leading example of how the commission's methodology just gets it wrong. The commission failed to do consideration. Because UPS points to a photograph of a mail truck in its brief and says, look, these trucks are huge. So that must mean that every dollar spent on these trucks, or basically every dollar spent on these trucks, a big proportion of the dollars spent on these trucks, they must be uniquely or disproportionately related to competitive products. The commission erred by refusing to consider them. And as the commission pointed out, it's nowhere close to that simple. So the discussion begins on page 1260 of the joint appendix, where the commission acknowledges that UPS is right in some sense. The mail trucks have got to be a little bit bigger if they want to carry a lot of packages. But, so that, of course, is uniquely and disproportionately associated with competitive products. But then the commission went on to say that's already captured by the existing cost attribution methodology and is indeed considered an attributable cost that mail products have to bear if they're competitive. And that's because, as the commission went on to say, quote, the difference between the depreciation cost of a vehicle sized to deliver only market dominant products compared to a fleet sized to deliver both market dominant and competitive products, that's at same page, JA 1260, that is the very definition of what is a cost attributable. And so, the thing that UPS says these trucks are sized to do, well, we're already taking that into account when determining what is a cost attributable to competitive products.
So you don't disagree with the way that the inquiry was framed by the other side, right? Which is that, yes, in theory, you could, in both in theory and in fact, there's a difference between what's already been attributed and what could be attributed. The question becomes, is there a way to attribute what's left over that works?
In theory, Your Honor, yes. And I want to be careful because I don't want to accept all of my friend's premises. What I will say is that in the 2020 decision, the court held that the commission is free on remand to, quote, explain why these two statutory phrases have the same practical reach despite the use of different language. That's at 1049 of the opinion. And so the commission quoted that language and then proceeded to do exactly that. And the commission said, well, let's take a look at every single one of these costs. Well, a big chunk of them, we're going to say, are cost attributable. And so those are by definition uniquely or disproportionately related to competitive products. And so it's, those, however, we're not going to consider for purposes of setting the appropriate share of institutional costs because they're not institutional costs. By definition, they are instead cost attributable. And, there is no such thing, I suppose, as Schrodinger's costs. A cost cannot be in two buckets at once. And so, having said that, then the commission looked at all of these institutional costs that are left over. And the commission said, look, in 2020, the court held that in theory, some of these costs might be uniquely or disproportionately associated with competitive products. The commission accepts that. But the commission says, based on what we know now, and we have high confidence in our econometric tools, we don't think we can do that. And we don't think that there is any sort of way to establish a meaningful association, much less a meaningful, unique, or disproportionate association between any cost in the institutional cost bucket on the one hand and a competitive product or all competitive
So I
products
think
on the
that's
other.
what you just said is what UPS, at least as I understand it, is disagreeing with.
Yes.
And that they say we should ask you, and so I'm going to, where in the appendix do you actually explain that you tried X or Y econometric method or this regression or that regression and found it not reliable to measure this difference between association and a causal relationship?
So I have a couple of answers to that, Your Honor. And the first is I just want to correct a little bit of opposing counsel's question, because opposing counsel says, the commission required some reliable methodology. That's not what the commission said. What the commission said was, instead just quoting directly from this court's opinion, there still needs to be some meaningful association. And so the commission was not, in fact, conflating for purposes of figuring out what is unique or disproportionately associated, the reliably identified causal relationship test on the one hand, and what this court characterized as the requirement that, there be, a unique or disproportionate, association demonstrated by some meaningful way. But, having said that, I think the other thing I should point out at the outset is the other side thinks that some regression is required of the commission. That appears nowhere in the 2020 remand order. That appears nowhere in the statute. And that's, in fact, quite far removed from most principles of administrative law, where one doesn't look at a statute and says the commission must perform economic analysis of this sort or that sort, and it's certainly not apparent on the face of the PAEA, which gives the commission vast discretion to consider these costs as the commission sees appropriate. And so
I thought it was less.
I suppose the question is, the NPRM and the final rule do repeatedly say no methodology exists. And then the next sentence sort of moves on.
Right.
And so if we wanted to look for the proof that no methodology exists, are you saying we should just take the commission's word for it? Or is there something concrete in the analysis that we can look to?
So there's a lot that's concrete. And so the analysis takes place at two levels. One is the commission's qualitative explanation for why its conclusion was correct in general with respect to the category of institutional costs generally. And the second is when the commission invited commenters to propose costs that they thought the commission's method, which was announced in the NPRM after remand, was wrong. So the commission recognized UPS, other commenters might disagree with the way we've thought about this question. So come tell us what costs you think are uniquely or disproportionately associated, and we're going to consider them too. So to begin with the general answer, Your Honor, the commission's qualitative explanation for why there isn't such a relationship and why it makes sense for the commission to conclude what it did is because the costs in the institutional cost bucket are related to both the production of competitive products and the production of market dominant products. And so the commission then said, as a matter of the tools we have available right now, we can't disaggregate how much is attributable to which and how much is attributable to the other. And so there is no meaningful way to say that any given institutional cost bears the requisite unique or disproportionate association to warrant consideration in this way. And so that's the justification that the commission gave, and the examples that it cited.
Basically, the statements that say, once we have this bucket of unattributed inframarginal costs, we've studied them, and basically, by definition, they are equally associated with both lines of products.
Or
Is that how to
at this
understand your
point,
point?
that's right, Your Honor. It's impossible to say right now that anything in that bucket is meaningfully, uniquely, or disproportionately associated with competitive products. And so that was the commission's top line conclusion. But then the commission said, we recognize that many people disagree. UPS obviously disagrees. And so, I would point the court to the discussion basically beginning at JA 1259 to 63, where the commission talks about trucks. UPS says that a lot of truck costs are uniquely or disproportionately associated, and the commission rebutted that in detail. And the other side's reply brief doesn't really have much of an answer to what the commission said, except to assert that UPS continues to disagree with the commission's analysis. The same goes with mail carriers, which the commission discussed at pages 1270 and 72 of the joint appendix. Here too, UPS asserts that the commission is wrong because look, there's a whole bunch of mail carriers and a lot more costs of mail carriers are uniquely or disproportionately associated with competitive products that the commission's is willing to acknowledge. And the commission here too goes through and explains why that doesn't make sense. The commission said, obviously the cost of mail carriers is measured in terms of what they're spending their time on. And so to the extent that they're spending their time walking packages up to mailboxes, then that's of course attributable to competitive products. But, so it is uniquely or disproportionately associated, but the commission has already put those costs into the category of costs attributable. So they're not institutional costs at all. But then there's everything else.
Can I ask one
Yeah,
more specific
of course.
question? I'm sorry. So I certainly understand this argument. When I was reading the NPRM on pages 510 to 11 of the joint appendix, there is a statement that seems in significant tension with that story and says, to the extent that future refinements in costing methodologies occur, should those refinements result in the economically sound observation of costs uniquely or disproportionately associated with competitive products, cost attribution would be updated to include those costs and it would no longer be classified as institutional. So that's a long sentence, but it sure seems to say that in our view, by definition, any future methodology that would measure any association would be thrown into the A2 or A1 bucket. And so this third bucket of disproportionately associated costs is a null set. I know, I'm sorry to give you a pop quiz if you're not familiar with that, but does that question make sense?
It does, Your Honor. I am familiar with that statement, and I don't think it undermines the commission's analysis in two ways. And so with your leave, let me try to explain why. The first is, as this court explained in 2020, and this I think is critical, there is no legal requirement that there be, as a practical matter, a cost that exists in the uniquely or disproportionately associated bucket that is not classified as an attributable cost. And we know that because on page 1049, the court said these two statutory phrases may have the same practical reach despite the use of different language. That's exactly the scenario that this court anticipated the commission might come down and conclude. And then from a theoretical matter, what Your Honor is saying is it just demonstrates how strong the commission's cost attribution methodology really is. Because, as that sentence illustrates, the commission is updating that cost attribution methodology all of the time. It's improving its distribution keys. It is making refinements to the way that it measures what costs are attributable to competitive products in, the sense that it's measuring what costs would go away if competitive products were to go away. And in doing that, the commission is saying, these costs were once classified as institutional, where they would only be, the Postal Service would only be required to bear, quote, an appropriate share of them. But now we're going to require that they be classified as attributable, which means that to the extent that they're associated with competitive products generally, or with a competitive product specifically, well, then the Postal Service has to cover that. And so their criticism of, this criticism for me is a little hard to fathom because it just demonstrates that once the commission updates its reliably identified causal relationship methodology to figure out these costs and adds more costs to it, they don't disappear, but instead they go from the category of institutional costs to the category of attributable costs where they must be accounted for by the Postal Service in the relevant senses under sections A1 and A2 of the statute. I'm sorry, Your Honor, I got pretty caught up in this. I noticed that my time has long since expired.
I want to make sure you have a chance to address the delta. I think I know what your answer is going to be, but I want to hear the delta between the 39% and the 10+%.
Yeah, so my first answer is statutory and my second answer will be practical. So as a statutory matter, there is no requirement that the appropriate share be set at current cost coverage levels. That is not at all apparent from the text of A3 or the text of section 3633B. To the contrary, the Congress characterized the appropriate share as, quote, a minimum contribution requirement, not a requirement that there be 100% cost coverage between competitive and market dominant products. So that's the theoretical answer. And as a practical answer, as the Commission explained, the fact that the Postal Service is currently able to reach 40% cost coverage just testifies to the strength of the market, the underlying power that the Postal Service has to set prices 40 at such a level as to capture 40% of institutional costs or something along those lines. But I think intervener's brief makes a good point when, they explain, and the Commission explains this as well, that current market conditions may not stay the way they are. And so what UPS is proposing in some of its suggestions is that this court require the Commission to set the appropriate share at what the current level is. And, that would basically freeze the appropriate share at the current snapshot in time and, essentially subject the Postal Service to a price floor that may be, in fact, too high if market conditions shift, as intervener's brief makes clear that they have begun to. I think intervener's brief points out that now the volume of competitive products is actually decreased. And so there's no reason to believe that current market conditions are going to persist. But that also relates to another issue that my friend on the other side has brought up, which is findings about the fundamental health of the market. You asked Judge Garcia, the other side, to point to the best evidence against the Commission's very detailed description of how it assesses the health of the market. And the best evidence that the other side was able to point to was the fact that the Postal Service has lost money. And they say that this is the smoking gun. A private enterprise wouldn't be able to sustain losses like this. But the Commission addressed that at length. And so although the other side characterizes what the Commission said as ipsy-dixit, if you look at what the Commission actually said on pages 1214 and 1215 of the JA, the Commission found that these losses are not driven by underpriced competitive products, but instead by sharp decreases in the volume of market dominant products, and also by the Postal Service's until recent obligation to pre-fund certain retiree health benefits. And, the Commission also found that were it not for the fact that the Postal Service was trying to extract value from its competitive products, the losses might even be more significant. And
is there anywhere in the appendix we can look to find out if the Commission thinks USPS has losses on its competitive products?
I don't know the answer to that, but I can look into that and find out, Your Honor, if you need. Okay. But, the critical point here is that, at the end of the day, the Commission has made an expert judgment about the health of the market. And the Commission has found that, Your Honor, I'm sorry, let me revise the answer to your question, because I think I can get at kind of what you're asking. What you're asking is whether there is evidence of deliberate underpricing by the Postal Service of competitive products, I think. And what the Commission found with respect to that is that there has been no evidence of the Postal Service engaging in that kind of underpricing. And to the contrary, the Postal Service has always exceeded the costs that it was required to cover. And the pages for that, I think, are 1219 and footnote 156 of the joint appendix, where the Commission discusses the evidence of underpricing and the lack of evidence of deliberate misbehavior by UPS.
Make sure my colleagues don't have additional questions for you, Mr. Shi.
All right, thank you.
Please, Judge Rogers.
I'd like to hear your response to Petitioner's argument that neither the Commission nor the court can ignore the plain statutory language where Congress made a decision that it wanted the Commission to look at separate things and advise, after essentially an empirical study, that what Congress was requesting was either not possible or made no economic sense in the way the commission understood what was happening in the market.
Thank you, Your Honor. I have two responses to that. Again, the first is legal, and the second is on the face of this record. So as a legal matter, there is no impossibility threshold in the statute or in the 2020 decision that led to the remand that we're discussing today. And this is important because the other side attempts to characterize Section 3633A and 3630A3 and 3633B as somehow demanding that the commission disprove the existence of additional uniquely or disproportionately associated costs beyond those that the commission has already determined are also subsumed within the category of costs attributable. Nothing in the statute says that, and nothing in this court's decision says that. And so the other side is essentially attempting to invent an evidentiary requirement for the commission that doesn't actually exist. But, the commission discussed that in detail, as I said in some of my colloquy with Judge Garcia, where the commission explained as a qualitative matter that, of course, recognizing the legal distinction between the sweep of reliably identified causal relationship, which is definitionally narrower than the legal sweep of, quote, uniquely or disproportionately associated. Nevertheless, right now, on the basis of the econometric tools available to the commission, there is no way to ascertain whether any cost in the institutional cost bucket bears the requisite meaningful, unique, or disproportionately associated relationship with competitive products to warrant consideration in this way. And I want to, I promise 2 points.
I understand, counsel. I understood your earlier response. But what I'm focusing on is a congressional requirement that this court remanded the commission to consider. And arguably, one might have thought the commission would have responded somewhat differently, other than saying in a conclusory way, we considered these factors, and here's our conclusion. I mean, in response to Judge Garcia's question, I understood you to say you might be able to provide us with record sites, but not that it's clear on this order what the commission actually did. I'm not suggesting you have to meet an impossibility standard, but as I understand part of the argument, the problem with the current order, in part, is it's a trust the commission analysis, and that's not good enough in light of Congress's specific requirements.
So I apologize for giving you that impression, Your Honor. I want to be absolutely clear. I emphatically reject the other side's characterization of the commission's order as somehow based on a trust me because we're the commission type analysis. And I emphatically reject the idea that the commission's record that it developed fails to contain the requisite evidence of consideration. And so, for example, the qualitative discussion that I was talking about with Judge Garcia appears at pages 1149 through 1152 of the commission's order, where it discusses its understanding of institutional costs. The commission's discussion of institutional costs is also scattered at various points throughout, where it responds to arguments about institutional costs. And so, I would direct the court to our brief where we discuss some of those other places where the commission discussed institutional costs in general at length, and in particular, the portions of our brief discussing those aspects of the commission's order, showing that UPS's assertion through regressions of some relationship between institutional institutional costs on the one hand and competitive products on the other simply just didn't hold up on any sort of, the commission's economic judgment. But in addition to that, I would direct the court to the specific pages of the commission's order where the commission discussed all of the costs that UPS was invited to bring up in response to the commission's analysis, because the commission said, we've looked at all of these costs. The way we've looked at them is we've, figured out what they actually, are after, and these are the costs that can't be said to bear a causal relationship to the production of competitive products. And after thinking about it, we have concluded that it is impossible right now to demonstrate the existence of such a relationship, and that warrants significant consideration. But then the commission said, we understand that the commenters and potentially even a court might have concerns about this level of understanding. So just to make clear, in our mind that, we have got it right, we're going to ask for evidence of costs that are allegedly institutional costs that do bear the requisite unique or disproportionate relationship, but are not already captured by the definition of cost attributable. And so UPS was invited to submit many of these costs. UPS listed a whole bunch of them in their briefs, focusing on peak season costs, for example, the cost of trucks, the cost of mail carriers, the cost of capital investments, the cost of rural carriers, vehicle service costs, institutional costs of that sort. And there are pages and pages and pages of the commission's order discussing all of those specific costs, explaining why UPS's assertion that those are in fact unique or disproportionately associated in a manner beyond what the commission's analysis admits was wrong, and then saying that regardless of whether UPS was right or not, the commission would consider those costs as if they were uniquely or disproportionately associated and reach the same conclusion anyway. Because at bottom, the section 3633A3 analysis, as informed by section B, does not mandate that the commission reach any given conclusion once it has determined what these uniquely or disproportionately associated costs are. Instead, it leaves to the discretion of the commission the decision where to set the costs, the appropriate share based on an assessment of, quote, all relevant circumstances, of which the prevailing market conditions are one, of which the degree to which there's any uniquely or disproportionately associated costs are another. And the commission faithfully discharged its responsibilities both under this court's remand decision in 2020 and under the statute, section 3633.
So one provision that came up in the other side's argument, but you haven't mentioned yet, is B9. And
yeah.
If
So
you just look at the text of B9 in isolation, we can certainly understand the submission that's being made.
yeah. So
To address that.
absolutely. So UPS is dramatically overreading what that provision is. It's not in the competitive product section of the PAEA at all. It appears as one of 9 unweighted objectives and 14 unweighted factors that the commission was required by Congress to consider when establishing and reviewing a wholly separate rate-making system, the one governing market-dominant products, as this court described in the NPPC case that we cite in our briefs. And as the NPPC case makes clear, those 9 objectives and 14 factors often point in different directions, and weighing them necessarily involves trade-offs. This court said in NPPC, the commission is best suited to make. So if this B9 section isn't mandatory, even in the context of market dominant rate system developments, it's really hard to see how it eliminates the commission's statutorily granted discretion in 3633B to modify or even eliminate the appropriate share requirement. And, furthermore, accepting the other side's interpretation of B9 would render section 3633B superfluous, right? Because in their view, B9 commands that, all costs of the Postal Service be allocated either to market dominant or to competitive products. But if that were true, it would be really odd for then Congress to grant the commission the discretion to set an appropriate share of institutional costs for competitive products, considering all of these things that we've been discussing during the rest of my time here. And it's also refuted, as the commission makes clear at 1112 of the JA, by the legislative history of the PAEA, which shows that Congress considered but then ultimately rejected the idea of requiring competitive products to cover their share of institutional costs. And, you know, to the contrary, in section in the legislative report that we cite on JA 1111, Congress said, you know, we don't want the commission to attribute 100% of its costs. Or, you know, we don't intend that the Postal Service be required to attribute such a large percentage to competitive products that competitive products will cease to be affordable. That just demonstrates, going back to the statutory provision that actually governs the appropriate share, that what the appropriate share does is it's not a costing exercise. It does not mandate, even if you buy every single one of UPS's arguments with respect to unique or disproportionately associated costs, it doesn't mandate that the commission do anything in particular with those costs when setting the appropriate share. To the contrary, as this court made clear in 2020, the commission retains the discretion to decide after making the appropriate consideration where the appropriate share should be.
Sure, my colleagues don't have additional questions for you at this time. Thank you, Mr. Shi.
Well,
Thank you.
I want to follow up on one thing then. Your position, as I understand it, is that UPS's interpretation of the word consider in the statute is nowhere supported by the text or, for that matter, the legislative history, that it had to do additional empirical studies.
Correct, Your Honor. So, and it's not just the position of the commission. You know, as this court described in the 2020 remand order, quote, "It is not for this court to say that the commission must account for costs in any specific way under section 3633B, or that the commission must make it."
My question is focusing on something else, and I was hoping you could respond to that.
So, you know, the commission has discussed the meaning of the word consider. And what the commission said in its order is that the word consider does not mean to, you know, do anything in particular with. It means basically, in plain meaning of consider, to think very hard about. And, you know, we describe the commission's plain meaning analysis of the word consider in the brief. The other side doesn't really attempt to rebut the commission's understanding of the word consider. And the court's decision in 2020 is entirely consistent with the commission's understanding of the word consider, because the court rejected UPS's invitation at that time to mandate that the commission do something in particular on the basis of what UPS claimed the unique and or disproportionately associated costs of the Postal Service were. The fact that this court left to the commission the discretion to reach the exact same conclusion on remand just underscores that the word consider doesn't have you know, the overlay that the other side would like to attribute to it. And moreover, the word consider doesn't have an implicit mandate that the commission conduct a regression of any particular kind. It doesn't mandate that the commission undertake a study of any particular kind. And, you know, to the contrary, governing principles of APA law make clear that statutes like this leave ample discretion to the commission to decide how best to do consideration. You know, such as, for example, the Supreme Court's recent decision in the Prometheus case, which I think we cite in our brief. And so there is no minimum quantum of empirical data that this statute mandates or that the 2020 decision mandates. But nevertheless, the commission engaged with all of the empirical analysis presented to it by commenters, including UPS, and then proceeded to explain why that empirical analysis, which was inconsistent with the commission's qualitative description of institutional costs, nevertheless made sense in light of currently available econometric principles. And so that's why what the commission did is fully consistent both with the statute and with this court's decision and with, you know, generally accepted understandings of what the word consider entails.
Thank you.
Thank you. Thank you, counsel.
Thank you.
We'll hear from interveners counsel now. Mr. Longstreth.
Thank you, Your Honors. John Longstreth for the interveners, and I'll just to try to be really quick because a lot of it's been hashed over already. We represent the users of the Postal Service. We have no interest in an uncompetitive market. marketplace. We want a competitive marketplace. We think there is a competitive marketplace. We have no interest in an unlevel playing field. Our concern is that UPS does want to tilt the playing field. There's an old saying distributed to Senator Magnus, and all anybody ever wants from the government is a slight competitive advantage in their favor. And we, UPS has been very assiduous about seeking that for decades now. Lawyers, economists, we have good economists too. And the Commission went with those economists, Professor Panzer. There are two of his declarations that go into all of these issues in great detail. The Commission went with him. The Commission's entitled to do that. But the point is, we use UPS as well. We do not have an interest in an uncompetitive marketplace. We think the marketplace is competitive and there's no need for intervention here. I'd like to just address one point that my friend made, which is essentially the trust us argument. Well, we might as well not have government at all if we just trust regulated parties to voluntarily comply. I'll put my love of government up with anybody else's. I understand we have a position. I understand we have a place for government where the competitive marketplace isn't working. This is not a case where the Postal Service is making voluntary contributions to some kind of institutional cost fund, like to some kind of charitable donation. They're operating in a competitive marketplace, and their pricing behavior in the competitive marketplace, where they're not price takers, they don't have market power in that. They go and operate in that competitive marketplace. And the result of that competitive marketplace is, as UPS concedes, a 39.2% contribution to institutional costs in 2021. So that's not something the Postal Service is doing out of the goodness of their hearts. That's something they're doing as an economic actor in a competitive marketplace. And UPS has shown no need whatsoever for the Commission to have the kind of heavy-handed regulatory intervention into that marketplace that they seek. So it's not a question of trust us, it's a question of trust the market. And as the Commission found, at this particular point in time, we can trust the market. The market is performing very well. There's also a thought that, since all their remedies are doing is mimicking the market now, it won't really cause very much harm. We think it could cost significant harm, and I think the Commission's counsel talked about that, where you're sort of freezing in. 2021, it was after the pandemic. There was kind of an upswing. What UPS would like to do would be to freeze that snapshot in time and then hold us to that regardless of what the market does going in the future. That could really create a problem. If you start sliding down, you create this doom loop. We kind of describe it in our briefs where, if the Postal Service starts falling behind, then under these kind of fully distributed costing mechanisms, UPS, once they have to start making it up by raising their prices, but they're in a competitive marketplace, they can't do that. And it just kind of spirals out of control. That's the thing that we as users of the Postal Service would be very concerned about, that they would be putting them in that kind of situation.
It hasn't come up today, and I'm just curious if you have an explanation.
Okay.
Is Postal Service's market share in a little over 10 years has doubled from 9% to 20%.
Yeah.
Might be an indication that something is amiss. And I'm just wondering what the intervener's explanation of that really dramatic rise is.
Yeah, they put a lot of evidence, they put a lot of effort into the competitive products into the competitive products business. They have a very, my client Amazon has a contract with them that's been a good contract for them and that has helped them grow their share. It's been good for us. It's been good for the Postal Service. I'm not sure I can really say what's going on, except that as the Commission found, and I don't think there's a shred of evidence in the contrary to it, it's not the result of the fact that there's some kind of, improper pricing going on by the Postal Service. That's going fine. So I'm afraid you might accept that just they're doing a good job with it. And we as Amazon think that they're doing a good job with it. That's why we've extended our contract. I think I think I can sit down. Thanks. Don't have to use all it.
Thank you, counsel. Ms. Sullivan, we have the 3 minutes for rebuttal that you asked for.
Thank you, Your Honors. 3 quick points. Judges Garcia and Rogers both asked counsel on the other side to show where was the analysis that showed that, as the red brief says at page 19, Currently available econometric techniques confirm that no institutional cost can be said to bear the requisite unique or disproportionate relationship. Mr. Shi gave you no answer, which leaves us with the conclusion it is conclusory. Mr. Shi referred to page JA 1170, but there the commission refers to detailed analysis. Yes, they used that word, but then it refers back to JA pages 1150 to 65. And I challenge the court to read those pages and find any analysis there. There is no analysis of a technique that was tried but failed. And the answer to that, Judge Garcia, you helped focus on with the reference to the NPRM, JA page 510. That's because it's not that the PRC looked for these cost relationships and found they couldn't find them. It's that they've ruled out disproportionately associated costs by definition, because they've said the only methodology that is economically sound is reliably identified causal relationships. We make that point on page 41 of the blue brief. Second point, Your Honor, again, very quickly, Judge Garcia, you asked, is there any evidence that there's underpricing of competitive products? Mr. Shi says, look at JA 1214 to 15. And no, we lose money because of the decline in market dominant products and our pension obligations. But that's false. There is evidence in the record that competitive products are part of the loss problem. And for that, I would refer you to the blue brief at page 51, which cites to the Postal Service's own 10Q, which says losses were due in part to the competitive products business. Just because you lose money on declining market dominant products and pension obligations doesn't mean you aren't also losing money on competitive products. The failure to consider losses from competitive products was contrary to law. And third, Your Honors, on 3622B9, which Judge Srinivasan, you brought up at the end, Mr. Shi says, oh, well, that's not part of the analysis because it's 3622A2, it's part of the A2 analysis, it's not part of the A3 analysis. But the Postal Commission itself has said otherwise. I cited you earlier, the easiest place to find this is Blue Brief 41. Blue Brief 41 is where the Postal Regulatory Commission says, even though B9 is outside of 3633A, it is the mechanism, A3 and B are the mechanism by which the Postal Regulatory Commission satisfies its obligation under B9. And the fact that it's one factor in 9 doesn't mean that you don't have to consider it. It's one factor of 9, but you have to consider it. By definition, they fail to consider it. The order is contrary to law, arbitrary and capricious, and should be remanded. Thank you, Your Honors.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 22-1029, United Parcel Service, Inc. Petitioner versus Postal Regulatory Commission. Ms. Sullivan for the petitioner, Mr. Shi for the respondent.
Morning again, counsel.
Good morning again, Your Honors, and may it please the court. Kathleen Sullivan for UPS. We turn now to a case that partially overlaps the case we just discussed and partially is different. Maybe I can start with the overlapping part since it follows from our prior discussion. We do argue here, consistent with our argument in the 1006 docket, that the orders conflict, the orders concerning seasonality costs, by which we mean seasonal peak package costs, which we think the record is undisputed, that costs go up in December because when people send out a lot of packages to coincide with the holidays in December, the Postal Service hires tens of thousands of temporary employees, substantially increases overtime, creates new special purpose routes, and acquires additional facilities. There's indisputably a seasonal spike in costs, and we believe that at a minimum, the court should remand in the 1029 docket for the same reasons we just argued in the 1006 docket. The Postal Service has, and I would argue by definition, said that it's not going to look for and hasn't found any seasonal costs that are uniquely or disproportionately associated with competitive products. Now, I think the only question there, Your Honors, is did we adequately preserve that A3 3633B argument in the 1029 docket? And the answer is we unequivocally did. I refer to Your Honors to JA 12, where the UPS petition raised the issue in the 1029 docket. JA 232 to 233, where the commission responded to our disproportionately associated costs argument. So it addressed the docket. It can't be waived if the commission discussed it. And the motion for reconsideration, we asked again, we said JA 247 to 48. We don't agree with your reasoning. Remember, of course, the commission erroneously, I think they would admit it was erroneous, they cited in 2021 back to Order 4963, which this court had vacated and remanded in the 2020 decision. So we moved for reconsideration, and then the commission rejected the argument again. So I don't need to belabor the A3
Can I
point.
ask about that?
Yes, Your Honor.
About the preservation of the A3 point. I mean, it just, the thrust of it seems to be, and if we start with A12, which is where it was launched, is that it's just flagging that there's an institutional cost question, but then just saying, yeah, but that's dealt with in this other proceeding. It's really, this is about, not about institutional cost, this is about attribution. And it just seemed to be kind of we want to make sure we put a marker here, but the marker is really going to be dealt with elsewhere.
Your Honor, we don't suggest that you have to, that the court needs to go into a detailed, we were incorporating by reference in effect the arguments in the other docket, but all we would suggest is that it would have the result that if in 1006 you agree with us, you should the court should remand not only in 1006, but also in 1029, including for the disproportionately associated costs failure on the part of the commission. So, Your Honor, we did put a marker. We didn't, it doesn't need to be belabored in a decision in this docket. All we want to do is say that, or in a way, this is the textbook example of our point in the 1006 docket, because here we have a case in which there is clearly disproportionately associated costs, that is, some costs more associated than not with competitive products, because people send more packages in December and they send less market dominant products in December. So it's a textbook example of the 1006 docket. We don't think it needs detailed analysis beyond the 1006 docket. We would just say that we preserved it in the 1029 docket as an independently sufficient reason for remand in that docket. But perhaps I could turn now to what's new about this case, which is the cost attributable argument. Here we do make an argument under A1 and A2. And I want to really focus on A1 here. It's A1, which was not addressed by this court in the 2018 order, or the 2020 order. 2020 was about A3. The 2018 decision of this court was about A2. Really, this is a case in which the commission has defied and acted contrary to law with respect to 3633A1. And why is that? Because this is a case in which competitive product volume decreases in December. Market dominant product volume, I said it backwards, competitive product volume increases in December. Market dominant product volumes decrease in December. That's undisputed. We have a chart at JA 54 in our comments before the commission that cites to undisputed data. That point is not disputed. And where that is the case, it is a failure it is a failure under A1 if the commission says, well, if you eliminated competitive products altogether, that's the incremental cost test, it wouldn't lead to any change. Eliminating competitive products altogether would eliminate costs that the commission has failed to take into account. Just to go back to the text of A1, A1 says there can't be cross-subsidization. That at a minimum means that the Postal Service has to have competitive products cover costs that would be eliminated if competitive products were removed altogether as a class. But the commission has failed to do that. The commission, it is undisputed, right? If we accept the facts are undisputed, it's undisputed that market dominant volumes decrease in December, competitive product volumes increase in December. The only response we hear from the commission is, oh, but hold on, first class mail goes up in December. But that's not the relevant comparison. The comparison is between the buckets of two types of products, market dominant products as a whole, competitive products as a whole.
I think part of their answer too is that to the extent competitive products are, driving more activities in December, that'll be captured in the distribution keys for, that quarter. And I'm not sure I totally understood the response to that, argument, that they're already capturing it, at least to an extent.
So, Your Honor, that's not good enough because let's start with the Postal Service's admission. The Postal Service treats much of the costs as institutional. So we've argued about how many of these seasonal spike costs are going into the institutional buckets because they're not being captured by the driver methodology and the cost attributable methodology. We say 500 million, but the Postal Service admits 250 million. So if the cost attribution methodology is not capturing all these seasonal spike costs, and we know that from the Postal Service's own admission, for that I would refer Your Honors to the Joint Appendix at 211, the Joint Appendix at 197. This is where 197, our comment at 211 cites to the Postal Service's own presentation to the Commission. I think the number on page 197 is actually 243, and we rounded up to 250 million. But that's still a lot of costs in the institutional
Can I
bucket.
clarify something about
Yes,
that
Your Honor.
slide? It says at the bottom that figure represents only 3.7% of December costs. And my takeaway from that was that must mean a lot of this December spike is being attributed under the USPS analysis, but I'm just not sure I'm piecing it all together.
I can't answer that directly, Your Honor. I'll have to go back and check. If there's anything to clarify, we'll be happy to do it. But what I'm really getting at is if it's conceded that the cost attributable methodology is not capturing all of the seasonal spike, there is an obligation under that. It's proof perfect that A1 is not being satisfied. A1 can't be satisfied if it's not capturing the entire result of the seasonal spike. I've already said that to the extent it's in the institutional bucket, they have to analyze it under A3, but we've covered that already. So why does this matter? This matters because we can see the incremental cost test asks, what costs would disappear if competitive products did not exist? And the Commission tells us none. If you took away competitive products as a whole, it wouldn't eliminate any of their costs. And that is, it's illogical. How do we know it's illogical? Look to JA 86. We have a presentation there that cites to items in the record. It basically, the Commission's own analysis is that the Postal Service, when it adds up all the A2 costs in its attribution methodology, comes up with a number that's essentially the same as its A1 number. To put it more precisely, at JA86, you'll see that if you sum the incremental cost of every competitive product and add them all up, it comes out to a number that's only 2.9% below the incremental costs for competitive products as a whole. That's the Postal Service's own analysis. That can't be so. It can't be that if you eliminate a product, the sum of the elimination of the individual competitive products adds up to the same sum as eliminating all of the operational costs that go with competitive products as a class, the trucks, the scanners, the additional size of the trucks, the additional sophistication of the scanners to handle packages rather than just letters. So what we're asking here is very simple, which is hold the Commission to its own methodology. We lost that fight in 2018. We're not here to refight it. Use incremental cost methodology. But when you do it, A1 requires you to examine the costs that would disappear, but for the existence of competitive products as a whole. And I think the data I just gave you that's cited at JA86, we looked at A2 and A1, and they come up to the same amount. That can't be right. Again, Judge Rogers, Congress doesn't enact separate provisions idly. A1 is a different command than A2. A1 asks them to look at the coverage of competitive costs, competitive product costs as a category. A2 asks them to look at the coverage of competitive products individually. It can't be that those two processes get you to the same number and are synonymous. Now, again, Your Honor, we proposed better ways to do this. They don't like our methodology. We're not saying adopt our methodology. That's the dispute. But even if the Postal Service quantifies the unexplained cost increase itself at nearly 250 million, there's got to be something wrong with the Commission's methodology. Don't have to adopt ours, but you have to command the Commission to follow the text of A1. That's
I
the
had a question about our standard of review.
Yes, Your Honor.
This is a denial of a petition for rulemaking, and we have a line of cases stretching back to Massachusetts v. EPA that says we apply an especially deferential standard of review in that type of a case. Now, I appreciate the Commission hasn't cited those, so it's certainly a question for them as well. But is there some reason that deferential standard wouldn't apply here?
Well, yes, Your Honor. I'm aware of the standard. It wasn't cited. What I think is the reason not to give deference here is the same reason this court gave at the 2020 order, which is that the denial of the proposed rulemaking is not reasoned, or its reasoning is not adequately explained. And I think the answer to the question is you can't be following A1 if your A2 analysis gets you to the same number as your A1 analysis. That plus the Postal Service's admission that there are $250 million or $243 million of costs that are not being attributed, but are going off into the institutional bucket. Those facial features of the record here suggest that deference is not appropriate because they are a failure to follow the law, A1, and a failure to give a reasoned explanation of the failure. So we don't think special deference is required here either by the procedural posture or by Chevron. We think it's a case of appropriate legal scrutiny by this court. I'll reserve the remainder of my time for rebuttal. Thank you very much.
Thank you, counsel. Mr. Shi.
May it please the court, I am still Mike Shi and I'm still here for the commission. I want to begin by zooming out and focusing on what the commission identified as the core problem in UPS's proposal, that it's premised on the existence of an attribution gap that in the commission's view just doesn't exist. And so the underpinning of my friend on the other side's argument is that there's this vast number of, quote, unexplained peak season costs that the commission has failed to classify as attributable costs. But as the commission concluded, UPS's calculations for estimating that are econometrically flawed and in fact almost seemed designed to create the impression of an attribution gap where no such gap exists. And nowhere in their briefing in this case does UPS really take issue with the commission's criticism of the methodology that UPS put forward for the existence of such a gap. So what they rely on instead, and this comes out most clearly in their reply brief, is the so-called admission by the Postal Service that there is an attribution gap of roughly $250 million or billion dollars, or $250 billion. And the intervener's brief at pages 15 and 16 make clear that that simply mischaracterizes what interveners are actually saying. Throughout the intervener's brief, they instead explain that what the Postal Service was really saying there was they were just adopting UPS's arguments and then saying, this is how we're going to describe what UPS is arguing, and we're going to use that terminology to try to rebut them. What those costs actually are, they're not unexplained in the slightest. They're institutional costs. They're the peak season costs left over after the costs attributable to competitive products have already been baked into the price floors under sections A1 and A2 of the PAEA. And so, this makes sense, as the commission explained, because of what these costs are. So most peak season costs, according to the commission, actually fall into one of two categories with respect to, costs in the institutional bucket, that is. they are either network costs, which are costs of maintaining delivery and processing and networks along those lines, or costs for activities associated with broad groups of products as opposed to competitive products alone. And so the commission in that way explained why the UPS's so-called gut instinct that there must be more of an association, more of a causal relationship than the existing costing methodology accounts for is just incorrect. And what this case seems to actually be about is a collateral attack on how the commission is implementing that cost attribution methodology, which this court upheld in 2018 and which the other side just acknowledges that they can't challenge. What they're saying is we acknowledge that the commission is already treating a portion of these costs as attributable. We think that the commission ought to treat a lot more of them as attributable than the methodology actually does. So again, they lost that fight in 2018 with respect to the use of incremental costs under Section A2, and with respect to the use of incremental costs under Section A1, on which my friend on the other side has focused her argument. I would remind the court that UPS actually agreed with the methodology that the commission used to calculate whether there was improper cross-subsidization when that regulation was first promulgated. And UPS, as I understand it, doesn't challenge the continued use of incremental costs to measure cross-subsidy in that context either. What they're really saying is in deploying these methodologies, the commission is doing it wrong because there must be this gap. And because your methodologies don't account for that gap, then there's something wrong in the way you're accounting for these costs. But
Please.
One question at the outset. Can I just ask, do you disagree with the proposition that as a class, not within the class, but as a class, market dominant product costs go down in the last month and competitive product costs go up? In part. And so what the commission said about that is, UPS's evidence of the volume decline of market dominant products generally reports averaged indexed volumes as opposed to the actual volumes, which as the commission made clear on page 230 of the JA, can exaggerate the significance of these volume shifts. But, the other piece of it that UPS is missing, of course, is that, not all market dominant products are the same. First class mail is a very, 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 very big part of market dominant products. And there is a December volume spike for first class mail that can also explain a lot of these costs in the institutional costs bucket. And UPS hasn't really demonstrated that the remaining institutional costs, right, the costs that are not already attributed using the existing distribution keys, the remaining institutional costs bear a reliably identified causal relationship or even a uniquely or disproportionately associational type relationship with competitive products generally or with competitive products specifically. And even if the non-first class market dominant products offset the extent to which the first class market dominant products may go up in volume, as a class across the board, market dominant products still go down.
As a class across the board, my understanding of what the commission said is that there is potentially a diminishment, but there is definitely an increase in the volume of first class mail. There is an observable first class mail volume spike. And so although UPS simply asserts that all market dominant products are the same, there's in fact, the commission came to the opposite conclusion based on the evidence that it had available. But this illustrates another feature of UPS's proposal that I want to emphasize, which is that UPS is laser focused on what it calls peak season months, but totally ignores non-peak season months, which also exist. And so if UPS is really committed to its proposal, and it really thinks that the cost attribution methodology is really wrong, what UPS ought to have proposed was, to take account not only of peak season increases, but of non-peak season decreases. And indeed, one of the problems with UPS's methodology that they don't respond to is that it produces volume or the so-called attribution gap goes the other way when applied to months where there isn't a peak season. And by focusing on the one without focusing on the other, they're giving a skewed view of seasonality changes. And so that's the reason why the commission decided to stick with its existing use of distribution keys, which apply quarterly and in consequence will capture any volume increases in December. Now, my friend.
Can you respond directly to so they, as you said, are focusing on A1 and the jumping off point for them is page 86 of the appendix. And there's certainly an intuitive appeal to the idea that the number that you would get if you truly asked what would happen if we offered no competitive products at all should be significantly more than just the sum of each product at each time. Maybe, your answer, on trucks, you just wouldn't need the same size of trucks or maybe as many if you just got out of this giant line of business altogether. And so could you just sort of walk through your response to that and the point about page 86?
Yeah, so the point on page 86 of the JA is an assertion that there is going to be significant reconfiguration of the Postal Service's products if it just stopped producing competitive products. And the commission has rejected that throughout, both in the prior docket actually and in this docket, right? So one thing UPS has always said is that the Postal Service is identical to a private corporation. If it stops producing certain lines of products, then it could immediately just revamp its operations to become more efficient, just like any other private company. And what the commission has said in response is that that's just not the case. The Postal Service is not any old private company. The Postal Service is governmental and is subject to the requirements of the PAEA and also subject to requirements that it maintain a nationwide delivery network to go to every delivery point, basically every mailbox in everywhere in a city, as far away in rural places and all across the country, including in Alaska and Hawaii. So it can't do the sort of wholesale revamping that UPS is hypothesizing might occur. Then specifically to the question about
where can we look in the order to find that? Because when I read JA 235, sort of confronts this argument that UPS says our models assume our operations are fixed. That's incorrect. And the next sentence essentially says we're constantly upgrading our costing system. It doesn't explain why you would not be able to revamp your operation. USPS wouldn't be able to if in fact it got out of the package business.
So this has been, as I said, a through line in UPS's arguments throughout this space. And so a significant discussion of it does come in the other docket that we were discussing today in the prior case, where UPS makes the exact same argument. And the commission makes very clear that the argument about being able to revamp one's operations that just doesn't really reflect the operational realities of the Postal Service. To the extent that you think that that's not adequately presented on page JA 235 or the other places of the discussion, I don't think a remand would be necessary for the commission to address that point. As this court explained in a case, I think, called Taurus Records, where it would be pretty clear what the commission was going to say, a remand would just serve no purpose at that point. And so here it's very clear what the commission is going to say. Indeed, I think there's a discussion of precisely this point about revamping postal operations in the absence of competitive products in the prior docket. And it's discussed here that, to the extent that revamping does occur, the Postal Service does modify its costing system to meet those operational realities. And so, given the combination of the commission's thorough refutation of this argument, which the commission has consistently pointed out throughout its postal rate making, and given the commission's discussion of why it doesn't believe any alteration to the incremental cost methodology is needed at this time, we submit that a remand would not be appropriate. The other thing that Your Honor asked about, though, was why the numbers for incremental cost with respect to A1 and what additive costs are under A2 are roughly the same. And the fact is that there's no basis for UPS's assertion that there should be a massive gap. And that's because we use the exact same methodology for both A1 and A2, but we apply it slightly differently. And so for A1, what the commission does, and again, UPS concurred with this methodology, doesn't dispute this methodology. What A1 does in the prior docket, and although it throws shade on the results that the methodology gets, what UPS can't say is that we should depart from the incremental cost test. What the incremental cost test does is it measures what would happen if every single competitive product as a group ceased to be produced. And that's the inquiry under A1. The inquiry under A2 is slightly different. The incremental cost is applied to individual products. And so the commission asks what cost would disappear if the commission stopped producing a given competitive product. The reason they get to the same result or there isn't this massive difference is because of the fact that A1 and A2 both depend on the incremental cost methodology. And again, with respect to A1, UPS previously conceded that it was reasonable. And with respect to A2, this court has held that the use of incremental costing as a methodology was reasonable in 2018. But I want to back up and just say again, right, UPS's case really does rest on an assertion that the existing methodologies are flawed because of the perceived attribution gap. And I want to reemphasize that UPS's has now abandoned its own methodology for proving the existence of such an attribution gap, and that UPS's heavy reliance on what the Postal Service said just misunderstands the Postal Service's discussion of that 250. So at the end of the day, the petition is requesting relief to solve a problem with the attribution methodology that the commission in its judgment has determined does not exist.
Can I follow up on a question that was raised earlier, which is that this involves a petition for rulemaking?
Yes.
So why is it that those standards that incorporate principles of prosecutorial discretion and other discretionary considerations that attend a petition to get involved in something aren't part of your submission in the briefing?
Your Honor, we focused instead on it. It was a little hard to figure out what UPS was arguing in its opening brief because UPS's opening brief kind of walks away from demanding that this court adopt any of the methods that UPS says you ought to adopt, and instead just focuses on these broad concerns about existing incremental costs methodologies being not capable of capturing the alleged attribution gap that exists. But certainly, we agree that to the extent that what UPS is asking for is, we demand that the commission do rulemaking of this sort. I see no reason why those additional standards wouldn't apply. But, to be clear.
But that is what happened, right? I mean, that's what this case seeking review of is.
That's right, Your Honor. The petition is a little bit confusing. On the one hand, the petition says we demand that you adopt this particular mode of, calculating these peak season costs for purposes of attribution. And in the interim, you do this interim thing. But then the commission launches, the petition launches what the commission took to be just a broader attack on the methodology writ large and said, your continued use of this methodology is arbitrary and capricious for a variety of reasons. And so, certainly we don't dispute that. To the extent that what they're asking for is an affirmative rulemaking by the commission, those standards would apply. But regardless, as the commission's order makes clear, its reasoning can be sustained under any standard and is a faithful summary of analysis of and of the underlying econometric arguments that UPS is putting forward in service of proving that there is an alleged gap in attribution.
Make sure my colleagues don't have additional questions for you.
No.
Thank you, Mr. Sheep. Judge Rogers, did you have a question?
No, thank you.
Thank you, Mr. Sheep.
Thank you, Your Honor.
Sullivan will give you 3 minutes for rebuttal again.
Thank you, Your Honors. 3 quick points. The standard of review, there is no deference to the PRC to refuse to apply its own test. We are not challenging what its methodology is. We are saying that the point is not that they're looking at these A1 costs the wrong way, costs that would disappear but for competitive products. They're not looking at it at all. They're refusing to apply incremental cost testing. No deference, no prosecutorial discretion in that kind of refusal. So that, I think, is the answer on the standard of review. Second, Judge Garcia, I wanted to get an answer to you on JA 197. This is on the size of the attribution gap. And Your Honor asked, well, doesn't page 197 in the Postal Service presentation say that these unexplained costs represent just 3.7% of peak season cost? I now have the answer, Your Honor. It's 3.7% of total December costs, but it's a much higher percentage of the seasonal spike in costs, which is what we think the incremental cost test should be capturing here by looking at how that seasonal spike would disappear but for competitive products. And the answer, Your Honor, why this is the 3.7% of total, it doesn't matter, is because the total seasonal spike is about $977 million, Your Honor. That's cited at JA 31. So the $243 million of unexplained costs by the Postal Service's own admission is a very substantial percentage of the seasonal spike. It's, almost a quarter that's unexplained. And last, Your Honor, Mr. Shi, and the revamping point, just to summarize our position on revamping, is if the Postal Commission applied its methodology we're not challenging the methodology. If they applied it, they should determine that if the Postal Service stopped delivering packages altogether, it would be able to revamp and take a number of steps. This is intuitive, to make operations more efficient. It would not need to purchase giant trucks for package delivery, specialized scanners for packages, seasonal increase, variable costs like seasonal employee size. It would be able to scale down given the precipitous decline of market dominant products. And I think Mr. Shi finally did admit under the court's questioning that market dominant products as a class decrease in the seasonal period when competitive products increase in volume. So revamping could occur. I think I heard Mr. Shi's only answer to that is revamping couldn't occur immediately. The Postal Service would not be able to revamp operations immediately. But that's exactly the problem. There's nothing in the current application of the incremental cost test. It doesn't require immediate changes. What we're asking for is that they apply their methodology so that they could revamp over time. And those changes would, a number of operations that are not captured by the attribution methodology as it's being applied today would disappear over time if competitive products did not exist. It's simply implausible. There is no such spike-related incremental cost at all. So we respectfully ask that you do remand, notwithstanding that it was a request for rulemaking, because there's no deference here. It's a refusal to apply the very test that this court allowed them to apply. We don't challenge the test. We challenge its failure to be applied. Thank you very much, Your Honors. We appreciate the extra time you gave UPS for the arguments today. Thank you.
Thank you, counsel. Thank you to both counsel for your arguments in this case and the other one. We'll take these cases under submission.